Okay, good evening, class. So I have noted from the feedback from the end of some of you that a good number of you are not settled. You seem to be like on the move, and that does not augur well for a smooth class. So I will do some discussion with you, and then give you more task so that we will have a seminar next week. So we would like to move on to the next thematic area for our discussion, which is comparative study of formation of incorporated companies or corporations. And as I have told you before, this type of model you are doing is a blend of, theoretical corporate law and also comparative substantive corporate law. So therefore, we would like to take an aspect. So we are taking the how you get the corporate vehicle, right? How do you acquire it? And if we look at the various jurisdictions, what are the arrangements, the parameters, modalities for acquiring the corporate form so that you are able to use it for your business purposes? Now, such a discussion is quite pertinent, and it's not just pedantic or just an exercise in sophistry, because we know that increasingly we are in a globalized world, right? And the increasing globalization means that businesses, and for that matter, investments, are not state bound. They are highly mobile and so on and so forth. And if that is so, we should be interested in understanding the legal arrangement for acquiring the corporate vehicle, which is the subject matter of this model. And that is what we want to look. But before that, just to pull most of the things that we'll be discussing by way of seminar in perspective and pull them together, just make some few general preliminary points on some of the things that we have encountered, and we are supposed to be very much well informed now if you'll be taking the learning serious. And so we are interested in exploring the issue: how did the company acquire the legal personality and its other attributes? And that is why we task you to look at the Lord Templeman's article on which I will refer you to, right? Good. House built on the faulty foundation and so on. And as still within the spirit of a comparative corporate law discourse, we need to find out that if we look at, not of course, if you look at our jurisdiction, if you take Ghana, we know that if you wanted to get the corporate vehicle, which will be clothed with legal personality and so on, and all the other attributes that we know, there is a dedicated legislation, right? A standalone legislation, which provides a framework for such a purpose. And that legislation we know very well is the Companies Act 2019, Act 992, which of course repealed the over 50-year-old Companies Act 1963 at 179 not long ago. So in our jurisdiction, there's no confusion whatsoever regarding how you could actually get this kind of a vehicle. But then we are interested in also exploring that if you go to other jurisdictions, for example, have they got a similar thing, like so that, or other jurisdictions take different approaches, right? So that let's say that if you look at even within our African context, let's say that if you look at Cameroon, right? Cameroon, where they have, if you like, a fusion of elements of civil law and common law tradition and so on, French and English. We'll see that they have like, if you like, a dedicated legal arrangements like similar to that we have in Ghana. Or you look at Canada, or you go to the US, which is highly federalized with a lot of states, and various states have got their own legal arrangements. Now, with respect to acquiring the corporate form, do we, for example, have like a federal framework, or there's nothing like one unified federal framework for such a purpose? And if you are interested in that, then you need to go to a particular constituent states so as to acquire that. So those are some of the matters that we should be interested in exploring. So do we have general incorporation legislation, or we also have a special incorporating legislation? If I say special incorporating legislation, for example, if you look at our jurisdiction, especially when it comes to the public sector, or the so-called like the PP, private PPP, private public partnership sort of arrangements, where they usually have a special incorporating legislation. Maybe you want to have like a special corporation or company to do particular aspect of business, then you go out of your way and you pass that legislation. Yes, what are the implications for that generally for corporate law and so on? And of course, let's say if you come to Ghana, we encounter some challenge, especially where you have like a special incorporating legislation. You take maybe some of these parastatals or some quasi-state corporate entities, and sometimes you do not know whether such entities must have their affairs run according to our general understanding of corporate law and so on, or you have to be more mindful of the public law requirements. And that is something that we should actually be concerned about. And of course, I just give you an example. Not too long ago, about 5 years ago, I had a case, and some Ghanaians based in the US, they had supplied things to this Ghana, what do you call the plywood veneer, right? This is the veneer company, which has more or less become the defunct or moribund now. And the company owed them, I mean, about $200,000 or something like that for things that have been supplied to them. But so they went through recovery process. They got a judgment, and when they got a judgment, execution became problematic because, despite the fact that the GVPC, the veneer, plywood, and so on, the shares were 100% owned by a government entity, I think the Forestry Commission or so. The company was no longer there, right? And the shareholder is still around, of course. There's a sovereign state is there with vast resources. But because of the corporate personality principle, because of the veil of incorporation principle and all that, if you could not locate assets of that particular company, you couldn't levy execution, right? You couldn't levy execution. So that is problematic. And let's suppose that the creditors might have been doing business with this particular company in the sure knowledge that this is a 100% state-owned company. And for that matter, if I do business on credit, I'm not going to run into any trouble. So the company is owing, the company has more or less become defunct. It's no longer operational, it doesn't really have any assets. So what happens? does it mean that you can ignore our elementary principles, right? That the corporate is separate from the stakeholders and so on, and just go after state assets, or in the name of trying to recover what that company which is owned by the state owns. So these are some of the problems. If, for example, you're having some of these special incorporating legislation, of course, we've also been thinking about the issue that if we take a company law regime, right? If we take a company law regime, how do we pitch the law? Should the particular arrangements that you have, should it be more relaxed in the sense that you don't interfere so much, right, regarding choices which those who are using the corporate vehicle for their purposes may do, or for fear of abuse and greater, if you like, trouble, which may be encountered, should you give them a lot of latitude, should you give them a lot of room to operate, must you be extremely prescriptive so that they have little or no room? So those are some of the matters. And very soon, as we move to look at comparative examples regarding the formation of the corporate vehicle and so on, we must be mindful of asking that the various jurisdictions that we are going to be looking at, can we say that in jurisdiction A, the regime is more liberalized than jurisdiction B or C or D, as it were? So those are the kind of things that I would like us to have at the back of our mind as we move on to do the next set of round of research, reading, and also like the seminar, right? Yeah, so as we have noted from our reading that those who will, yes, Mr. Ayebo Osuyama. Yes, Mr. Osuyama, go ahead. Mr. Ayebo, oh, your hand is up.
Yes.
Yes.
Sir, yes. Sir, please, you have kept mentioning corporate vehicle. I want to know whether it is the law that you are talking about. In the case of Ghana, if we have Act 992, is it the 992 you are talking about to be the corporate vehicle?
No, if I say the corporate vehicle, I'm talking about like the entity, like the form. You know, like when you've gone through the particular legal, let's say that in Ghana, right? If you take our current Act 992, that if you want to get a corporate form, if you want to get in the eyes of the law, what do you call like the corporate form or the model or the vehicle, the same thing, just interchangeably. If you want to get that so that the law will see you as having the status of entity, you know, like the various things that we'll be discussing from our previous seminars. That is what we are talking about. So like the vehicle, the corporate vehicle we're using is actually synonymous with the corporate form or the corporate business entity, right? That is what we mean. I don't know if that is clear, Mr. Isuyama. Let me see. Isuyama, I don't know if that is clear to you.
Sir?
Yes.
So the corporate form is the registration. So once you register, then you gain your identity as a corporate body to run.
Yeah, so no, it's you getting the the end product. When you've gone through the registration or the incorporation processes, what do you get at the end of the day? What you get is a corporate form. What you get is a corporate vehicle or the corporate entity, isn't it? So that is what we are talking about.
Okay.
So Doc, please, can we equate the vehicle you are making reference to here to be the company formed under the Act? Is it the same?
Yes, that is it. You see, that's the same thing. But what I am doing is that because all those who subscribe to this model have done undergraduate company law, right, in Ghana, our focus is not only on the mundane or the elementary things that we know already, but we are using knowledge of those things to feed into our discussion. And so what we are looking at is that, so we are looking essentially at two things. Most of the things that we know, we want to understand why, let's say that our law has been configured or have been made the way that it is. And that is why from the various theoretical discussions that we'll be reading and all that, those are some of the things, ideas that we get. And we haven't finished. When we move into the realm of corporate governance, we'll be learning more about this Chicago School of Economics and its relation to corporate law and all that. And you begin to understand why, for example, certain types of arrangement, let's say when it comes to the corporate governance, members, general meeting, directors' powers, the do's and don'ts, and so on and so forth. We begin to understand the why behind them. And then we also begin to see how comparable jurisdictions have actually also approached such a matter. And then what can we learn from some of these jurisdictions? I think that is the point. And that is why, in terms of like the proper purpose of company law, we've already discussed that two or if you like three main things. Should we regard, so, and again, you have to be asking ourselves as we go to do the comparative exploration, that in a particular jurisdiction that we are dealing with, do we see the law, the company law, the corporate law, or the corporations law, however it is called over there, do we see it as being more, if you like, I don't want to say like business friendly, or like more facilitative, more supportive? Is the law structured in such a way that it makes things easier, right, for users of the corporate form, the corporate vehicle, to be able to use it? So those are the kind of things that we are thinking about. Or is it the other way around? If it is very supportive, then some scholars will, for example, try to rationalize it in this way, that if we look at society, if you look at the economy is synthesis. It's a nexus of contract. It is a synthesis or agglomeration of various economic entities, no less the business entities and so on and so forth. And if that is the case, if commerce, for example, should flourish, what that means is that businesses or companies or corporations are doing well. And if companies or corporations are doing well, that is going to inure to the economic benefit of what? Of society. And if that is so, then the law should be structured in such a way that it will enable those who are using the corporate vehicles, the company forms or the corporation, the companies, it will enable them to be able to do their businesses that they are doing easily, conveniently, without unnecessary bottleneck, bureaucratic requirements, red tapeism, and things like that. So the law should, as it were, have more or less like what we call like the law should take a backstage and allow those in charge of the corporations and so on to be able to do things rather than trying to draw a lot of red lines. Don't do this, don't do that, or do this way, do this that way. That way, things become problematic. And of course, as we think about that, we also need to look at whether we think that, depending upon the size of corporations that you are grappling with, so that if you have, let's say, that small, medium type of business entity, like the private companies, as we call it in our jurisdiction, then should the law have more or less like the offhand, like yes, you can do things which are really convenient to you, however it is, and very little regulation. Should that be the case? And then, or when it comes to the big size, the large scale corporation, the huge companies, the public companies and so on, then you have more restrictions, or which way? But isn't it rather the big companies which have huge turnovers, which can actually impact on the economy and a lot of people and all that? And if you agree that that is the case, shouldn't you be more liberalized towards them? So those are some of the things that we've been discussing, and we keep encountering some of these matters as we go on. And again, we also have the other side of the spectrum or the continuum, that those who are of the view that yes, the corporate form is a good thing, which was discovered through early Roman law thinkers. And then later on, English law also seized upon it, and leading to the famous developments in Solomon and Solomon and so on, is good. Nevertheless, experience have taught us that companies, business companies and so on, that much as they can be forced for good, they can also be tools for great evil. And if they can be tools for great evil, then they should not be allowed to have a filter. You need to be very prescriptive. You need to guard and police it so that corporate power is not abused, or the company does not abuse things and so on. And some will make mention to a lot of problems that we have seen. And of course, if you come to a part of the world, there'll be some sort, like, if you like, a knee-jerk reaction. For example, as far as if you come to the financial sector, for example, the meltdown that we had, and how all of a sudden a lot of rules are changed here and there and so on, with the aim of trying to arrest recurrence of the unfortunate situation that we have witnessed. So those are some of the things which may, for example, drive some policy makers, lawmakers, corporate law commentators to favor company law, adopting the approach of a strict regulator rather than being liberalized or liberal, as in the company law as a facilitator that we have seen, as it were. And of course, related to this is also the idea, and we've seen some aspect of the problem of agency costs, right? Or the agency problem in corporate law already. That brings the idea of what they call like the stakeholder. Like, when it comes, who are the stakeholders of the company? Who are the stakeholders? Are they just the shareholders who then select their directors who run the company and so on? Or are there wider constituencies that may also be seen as stakeholders within the corporate vehicle, as it were? maybe employees, creditors, or even the state, because the state is more or less like a regular creditor through taxation. It is the taxes and so on, isn't it? So the state is entitled to get some money from the company. So is it also a stakeholder? Then the environment and all that. And as we move on, if you look at, let's say, modern company legislation, including our own Act 992, you notice that certain requirements, certain objectives have been brought, right, within view regarding how we can evaluate whether those who have been given powers within the company, such as the directors or officers, whether they have used their powers properly or not. What was the objectives and so on. Certain things, including even the environment, right? And also the particular corporation having positive ethical outlook in society, that it is an ethical company and all those things. All those have actually become relevant, and they have even made their way into legislation which govern the powers and duties of board of directors. And that seemed to suggest that by and large, more and more entities are being recognized as forming part of the stakeholders, right? And if that is so, then certain basic principles, for example, if we take the doctrine of Travaris, the doctrine of Travaris that we knew, right? If you take our old law, it was a big thing, and building on from the Asbury Railway against Ritchie and related jurisprudence, that the company has an object clause in its constitutional document. And for that matter, it must always stay within the four corners of that. Unless, if you look at the Eastern Railway against Attorney General, unless the particular thing is incidental to stated purpose and object and so on. Other than that, the company is said to have acted with Travaris. Directors is said to have acted with Travaris, and so on and so forth. And the related concept of the indoor management and all that. All those things are manifestations of having a stricter company law regime, having a regulatory regime, right? That the company cannot just pick and choose and do whatever that it wills. What it has told lawmakers at the time that it was registered, at the time that it was incorporated, it must stay true to that, unless it has gone through laid down procedure for making requisite changes or amendment. It cannot choose, it cannot do cherry picking and do whatever that it wants. No. If it decides to deviate from what it has registered from, it will be struck down or it will be questioned as doing something illegal, right? But if you look at the modern trend, the issue has only come about that we don't set up company just for the fun of it, right? We don't acquire the corporate form for the fun of it. We acquire the corporate form for the important purpose of allowing us to take advantage of business opportunities, right? Situation which may come. If that is the case, why shouldn't you have a free hand so that depending upon what we consider to be lucrative, right, in terms of profitability and so on, we're able to take advantage of it? Why do you have to, for example, go through amendment procedures every now and again before we can actually make some deviation from what we have been doing. Let's look at this situation, for example. Nobody all over the world, right, anticipated that there was going to be such a pandemic like the COVID-19. And then last year, from nowhere, COVID-19 struck the whole world. So that also changed the business environment. Certain things, certain things became more profitable to pursue because there was a high demand, right? High demand for that. And other things too became more and more unprofitable because the demand actually slumped. So if you are a company, for example, why shouldn't you be able to just take advantage of the changing trend? And a lot of companies which were doing things not related to some of the things that we see now, they just have to turn around and take advantage. So that flexibility is what we are talking about. And concepts like ultravirus, right, do not actually augur well for this kind of flexibility. And also having a very strict and doctrinal type of indoor management also stifles flexibility, and that is also not good. And in some respects, that may be seen as a manifestation of a stricter regime of company law. And again, you come to capital maintenance, another potent, manifestation of the company law regime being more regulatory, being more stricter. The company is there, is meant to raise money and so on and so forth and all that. Why should you police the company so much regarding how it raises money and so on? Of course, if you look closely into the rules which govern the company being prevented from depleting its capital so raised, except maybe the normal trading losses, you may also see some wisdom in it, isn't it? And if you look at even our own jurisdiction, the example, let's say that the rule against providing financial assistance, it makes sense because if the company is, for example, supposed to raise money from giving us securities or shares, how sensible will it be for the company to be giving money to other people to acquire its own shares? Just like the accounts will say that if you cut your own tongue and you chew it, then you haven't really enjoyed any remit, as it were. So in that respect, maybe some wisdom will be seen from that. But we are just using this to refresh our mind so that as we go into looking at examples which pertains in various jurisdictions concerning acquiring this form and all that, be able to ask ourselves some of these questions. And of course, thankfully, we've already referred to the World Bank's Doing Business report, and I'm sure that some of you have already started looking at that. And all those things, you notice that they are based upon some of these contextual issues that we are exploring. So another thing in terms of context for what we are going to do is the recognition that if you look at the political economic milieu, right? The political economic milieu, or the epoch within which corporate law, and for that matter, the corporate form actually emerged, you notice that the political economy, especially speaking in reference to English company law, the political economy was more of a laissez-faire, right? Laissez-faire. And if we look at the famous Adam Smith's work, the Adam Smith work, an inquiry into the causes of the wealth of other nations. And that was around the same time that the modern companies that we know had actually started evolving. And the underlying political economy was essentially laissez-faire. That is to say that it was more of like the, what do you call like the private sector, a capitalist, right? Capitalist, where you allow demand and supply to drive choices, so that where there's more demand, what it means is that the prices can go up and more profit can be made if you decided to supply or operate in that particular product or service, and vice versa. And if the corporations, companies are making decisions or any calibrations and so on, they are actually driven, right? They are driven by profitability, maximization of wealth, maximization of shareholders' value, because that is profitability. So that was the underlying political economy. But over time, there has been a drift from that political economy towards, I wouldn't say towards socialism, right? No, I mean, that is extreme. But towards the center, right? They've been like they move like towards the center, so that corporate entities are now being fixed with social responsibility. Companies are being seen as citizens, and if they are citizens, then they must have their civic responsibility. For their civic responsibility, that is social responsibility. And that means that corporations or companies should not just be interested in maximizing stakeholders or shareholders' wealth in terms of profit maximization, but more importantly, should be interested in running a business in a way which, for example, not be detrimental towards the environment, right? Would not be detrimental towards the health and safety of the community, would not be detrimental towards the welfare of employees, workers, and so on. So these are some of the new things, and that obviously suggests to you that the company is not just expected to be driven only by the quest to make profit or enhance profit as it were. So those are some of the things that we should have in mind as we move on. And I'd just like us to, so yeah, we've talked about also the fact that the company should have what they call like the multi-stakeholder, right? Multi-stakeholder perspective. Multi-stakeholder perspective in the sense that it should foster business relationship with suppliers, customers, and others, right? As it were. And you've also talked about the fact that there's also emphasis on being interested in the impact of the company's operations, right? On the community and also the environment. And again, the desirability of the company maintaining reputation for high standards of business conduct. And the good thing is that if you look at our current Act 992, you see that reflected, right, in the duties of like the directors. And that is one of the things they are supposed to have in mind. And of course, companies are also supposed to act fairly between the members of the company. And that is why we have a more nuanced exception to the so-called rule in force and habitum, right? What they call like the remedy against oppression and so on. All those things are meant to ensure that there's a fairness between members of the company, and no one is exploited or discriminated against. Now, the other thing, which is also worrying, or which is a matter of concern, as I said, is also about like the size of companies, right? The size has implication on how we pitch or we structure our company law. Should we say that the smaller the company as a business vehicle, then we should have less and less disclosure requirement? If we look at Ghana, that has changed. Now, in the new law, for example, we have a provision which requires what we call disclosure of beneficial shareholding or beneficial ownership of shares, meaning that if you are holding shares and let's say that you are not the ultimate beneficiary, right, of the share. If you are just a trustee or somebody is using you as a front, the law requires that you have to disclose those who are the beneficial owners. Of course, it's an attempt to fight corruption, especially those who hold the public offices where they will steal money and use them to acquire shares in companies, not in their own names, but in the names of some other people and so on. That is why we have those requirements there. I'll be just winding up very soon. Just okay. So, what I'm just taxing you to be interested in. Of course, just one general contextual thing before we come to that. Let me say a few words about the internationalization or the globalization of the corporate law. Yes, if you look at corporate law or company law, it is one area of the law where one may discern the need for convergence, right? The need of convergence, coming together of various corporate legal systems. And why do I say that? Let's take the situation. A lot of companies, let's say in the US, they are doing business in China, right? Some are doing business in Ghana and all that. Singapore, London. So let's imagine a situation where in all these jurisdictions, we have radically different corporate law system, right? That may not really augur well for smooth business relations, operation, also investment decision making. So, question is, can we see that there are signs of various corporate law across jurisdiction either coming together or diverging, going apart? Well, one may point to, let's say, the International Monetary Order, under the auspices of the International Monetary Fund, the Bretton Woods institution, World Bank, and then the IMF, and so on. And the argument may be that there's been like a breakdown of that. And you all remember how these institutions came about. It's just a shame that we are not doing how do you call it, international monetary law. Otherwise, we have learned something about the SDR, the special dwelling rights, and so on, and how they are tied to the rare power of states. They are good and things like that. When we talk about like the power of states, it's not so much about the noise that you are making, but it's about the size of your pocket. And the size of your pocket is about the gold reserves that we have. And it's the gold reserve which actually back your currency. And the quantity of gold that you have entitle you to certain SDRs or special dwelling rights and so on and so forth. So since the end of the Second World War, we have seen that there's been increasing development of multinationals and transnational corporations, right, and enterprises, meaning that businesses are not confined to one jurisdiction. Of course, that is not something completely new, because if you go back to the history of development of corporate law, remember even like the South Sea bubble, right? The South Sea bubble scandal, the East Indian Company and so on. I mean, even as far back as the empire or the colonial days, we had that kind of, that idea of multinationals or transnational. But of course, that was not on a proper legal footing. So post Second World War, we see this in a more refined shape. And you will notice that these multinationals or transnationals are very important forces behind globalization, and also in drafting and calibrating international norms relating to corporate governance and so on. And it will surprise you that these multinationals and transnational, they're even more powerful than sovereign states, some sovereign states, right? There are a lot of companies which are more powerful than even the whole of Africa put together, right? Some companies are just like that. So much wealth and so much influence, and they control like a lot of things in the world and so on. And these corporations with so much wealth and all that, some are so powerful that they even defy government regulation or government control. It's like they come to your country, and that's why the fact that they have come to your country, they will actually dictate the terms of engagement, right? They will sort of like define what the rules of the game should be, and so on and so forth. So that tells you how powerful some of these companies are. And these matters we are talking about are quite important, and they have a lot of implication, especially in legal theory when it comes to things like harmonization, right? Harmonization has become a very serious matter. What do you mean by harmonization? That is, if you take, let's say, Africa, for example, right? Now we have this African free continental trade agreement after and all that, headquarters in Ghana. Good. So the argument is that if we are trading closely among ourselves and we are trying to form a sort of like an economic bloc, as it were, then we should also need to bring our law relating to business, especially relating to corporations, closer. We should harmonize. We should try and frame a law based upon common ground, based upon points of consensus from an otherwise divergent or different corporate law system, right? And of course, the power of multinationals and transnational corporations also find another implication in the area of legal transplant, right? Legal transplant or transplantation in the post-colonial context. What do you mean by that? That is to say that some of these multinationals and transnationals are so powerful that they may want the corporate law in their particular host jurisdiction, that is a particular country that they have maybe a place of business, or they have set up a subsidiary, right? Or a national branch or whatever. They may even instigate and work hard to try and get their laws, right, to be aligned or to be framed in a way which is convenient to them. And sometimes they can even manage to get the law in the whole state that they are being made less and less restrictive and regulatory than even their own home countries. So there are certain things that they cannot get away with in their home countries. In their host countries, that's where they are. They'll be able to get away with it because they have been able to call the shot. They've been able to detect the legal norms, how they should be calibrated as it were. So all these are some of the contextual issues that we need to have in mind. And of course, not even to mention that some of these multinationals and transnational companies, they are powerful so much so that they can even instigate change of government, either through normal democratic process, funding particular political party or certain entities to win power so that they'll do their bidding, or in some worst case scenarios, even sponsoring military coups and so on and so forth. So that tells you how some of these institutions are. And all these things have resulted in what we call the decline in the role of states and the growth of corporatization together with privatization of public interests, right? If you look at some jurisdictions, including our own, when we used to have a lot of companies which were state-owned, providing a lot of services, the utilities and others. Now, multinationals and transnationals, so powerful, and then they even hide behind some of these Bretton Woods institutions and all that, and they've succeeded in pushing the agenda of what we call the privatization. And privatization and divestiture means that companies which were previously 100% state-owned and so on have been forced to actually privatize so that the state will either substantially cede its shareholding or it will reduce its shareholding and so on and so forth. So these are some of the things that I would like us to have in mind. Now, in view of the problems, right, which multinationals, transnational corporations are creating around the world, and the problem they're also facing in some parts of the world, the UN has a body we call the Commission and Center on Transnational Corporations, and they have done a number of work studies, and then they try to stimulate adoption of treaties, conventions, or declaration relevant to business. And some of the things that they have done actually try to provide a code of conduct, let's say for multinationals or transnationals, and then also to deal with the bribery and corruption. If you go to UK, for example, we have what they call like the Bribery Act of 2010. And this is as a result of some of the work which this body has actually done. They also provide research support and other things. And not only that, if you go to the OECD, right? And the OECD has also provided the useful guidelines for multinational enterprises and how, for example, host countries should exercise control over multinationals, and also legal liability of a parent company for debts of its subsidiaries, which it controls. And most of these multinationals or transnational corporations, what they actually do, as I said, is to incorporate subsidiaries or register subsidiaries in their host states, so that the parent company will be in the metropolitan or their national state, as it were. Of course, their guidelines also seeks to guard against discriminatory treatment of the labor forces in the host countries. And multinationals are actually guilty of this, right? They will bring their expatriates, the same company, let's say in Ghana, some of their workers are expatriates. They are giving better and special package than their counterparts who are doing the same work, right? So those are some of the things. And of course, also transfer pricing. That is another problem. You produce things at the cheaper cost somewhere, and then you take them to another place and you go and sell them at exorbitant prices and so on. Okay, so in the light of all this, I think 2 years ago, there was one student who did the work. That was a dissertation. And what they did was to try and explore the possibility of harmonizing company law in Africa. In other words, can we get a common framework, right? Corporation law which will be acceptable and mutually intelligible to the various jurisdictions that we have. Okay, so this is what I want to focus on. We are going to do a work, and the work that we are going to do is essentially research, right? And you present your findings to the plenary class, and which will also be part of your continuous assessment. The indicators I have provided here are not exhaustive, right? But they are representative. So the question that you have, let me just jump there. We come back to here. Now, the question that we have is that I would like you to select any 4 jurisdictions, okay, of your choice. And then you are supposed to compare, right? Compare and contrast the law of those chosen jurisdiction, right? With respect to how business may be registered as a company and how you may start using that to do your business. And I would like you to also be interested in exploring the possible rationale and underpinning the differences. So the 4 jurisdictions that you selected, maybe you selected, of course, it will be useful to always include Ghana, because in life, we say that we start from the known to the unknown, isn't it? The known is Ghana because that is where we studied. So we know the Ghanaian legal position. So that should provide that some reasonable basis, right? For us to be looking at the other places that we don't know. And maybe you take Ghana, you want to take probably Germany, Singapore, Australia, or you want to take Ghana, South Africa, France, Brazil, whatever. It's really up to you. But now when you have done all that, right, the related task is that I would like you to find out the desirable features of the jurisdiction that you've selected, which in your considered view ought to be incorporated in Ghana's Companies Act 2019. Should there be opportunity for change, right? If we're ever going to make some more changes, are there things that we have seen which are absolutely important, useful, beneficial, and you think that it should be reflected in our own law? And we like you, so the question is, that is why I said that the desirable features. So it's not just a question of saying it. You must demonstrate why you think that is really worth emulating, and then it should be incorporated in our law as it were. So let's keep that in mind. And to do that, there's a nice library I've given you already. That is the Global Library of Companies and Corporation Registration Law. It's over there, and just doing business.org.law. So, as I said, the basic things I would like you to find out, among other things, establishment or registration procedure, right? The particular place that you've taken. How is it like? How is it done? And so on. And also, while looking at that, I'm also interested in the timeline, right? So like how long will it take for you to be able to go through that process, right? And then in relation to that, are there types of recognized companies or business entities in your chosen jurisdiction, right? We'd like to find out that. And I'm also interested in you finding out, after you've gone through the registration process, right? Are there post-registration requirements for maybe commencement of business? For example, in Ghana, prior to the Act 992, under the old Act 179, we had Section 27, 28, 29 on the commencement of a business. And that when you had gone through the registration procedure and then you've acquired the certificate of incorporation and all that, it was not enough for you to start doing business and so on and so forth. And even quite apart from that, now, depending upon, there are even some other things, right, which you maybe need to get, and maybe other some tax registration and so on and so forth, or even if you are in a specialized type of a company, maybe like a bank, you need to get a license, insurance, and so on and so forth. Then the effect of registration, right, which we know in Ghana, is it the same for all the jurisdiction that you've selected, or the law approaches it differently? And then you can also find out, is it, for example, possible for you to have to reserve a name and so on? And with respect to capital, right, capitalization requirements is subsumable under point 2. That's a post-registration requirement for commencement of business, so that we're also interested in finding out, is there any minimum capital requirement, right, which you must have before you can start using the the corporate form. So these are the things that I would like you to think about, and I'm giving you now, and next week, right? We have a class, hopefully not on Wednesday. I mean, our next class very much likely to be a week today, Friday, because I may be away for a bar conference or something like that. So I'll send this material to you, and then you have the task. Now, I would like all of you to do individual work, right? Or no, okay, let me see. How many are you in this model? Are you 8 or Oliver, how many are you?
On the average, we've been 8. Okay,
So,
Mr. Jabulo is not here. So
okay,
yes,
now,
yes,
because
yeah,
I don't know the exact number, it's going to be individual. Everybody should do individual work, right? So do it alone. And I'll be taking your separate responses. And then when we're having the seminar, I'll call you as individual to make your own individual contribution. Is there any other thing? Otherwise, I'm ending the class. And I'm sending you this on your platform now, okay? I'm talking about the material so that you know what I'm talking about. Yeah, your hand is up. Go ahead.
Yeah, sir, please. My question is, when I was reading the Solomon versus Solomon case, the temple built on 40 what, I realized that we have a parent company. We also have a subsidiary company.
Yes.
If you have a parent company and a subsidiary company,
yeah.
Is the subsidiary company, assuming the subsidiary company is established in a different jurisdiction, is the subsidiary company required to pay taxes to the parent company's country or to pay to where the company is doing business?
Okay, so that one is really purely a matter of tax law, and taxation or tax law is really jurisdictional and territorial, right? It depends upon the particular country and then the tax system that you are talking about. Of course, except that in some countries, you have what they call the agreement against double taxation. So that if you see, like, you don't have a situation where the parent company is paying tax, and then the subsidiary overseas is also paying tax in the same nationality of the parent company, and so on. So it will depend very much upon the law of the country that you're dealing with. You cannot generalize, but it will depend very much on the country that you're dealing with. So that is what I can say. Yes, any other? Okay, let me send this. Can you confirm that the material had come? Check the platform, the corporate law platform, and let's see. Is it there?
Hello.
Yeah, yes. Go ahead. We can hear you. Go ahead. We can hear you. Go ahead, please.
Hello, Doc.
Yes. Go ahead, please.
Yeah, good. Thank you very much. You took us through the procedure by which you would want the assignment done.
Right.
I'll be grateful if you could just touch on one or two things for us, because You know, anytime you assign us to a task, there are some things you want done in the assignment. And so I'll be grateful if you could take us through the procedure by which you want the assignment done again.
Oh. Can any of the class repeat or summarize what I said, please? Can anybody tell me what he or she understood?
Sir,
Yes.
sir, please, you said we should compare it. We should compare 4 jurisdictions. And then you gave us the basis for the comparison. You mentioned that we can compare based on, a second, please. I took a snapshot of it, so I want to be sure.
Check the platform. I put it over there.
Okay. So you mentioned that the basis of comparison or the key indicators includes the establishment or registration procedures and the types of recognized companies or the business entities. That is the first indicator that you want us to look at. Then you also mentioned that we could also look at the post-registration requirements. And here you are talking about the commencement of business. We could also touch on the capital requirement to start the business. And then the third point is that we should look at the effects of registration or the effects of incorporation.
Okay.
And then the last one is the business name reservation.
Right.
That is what you mentioned.
Yeah. Yeah, so that's it. And I've also told you that there is a very useful website run by the World Bank, right? Which I put a link on your material. So you can just put it to your, Google it in your browser, and then you have a very useful information. Okay. Chris Atawoni, I hope you assisted.
Yes, please. Thank you.
Okay, so have a good night, and then let me get the work latest. So you are supposed to, you do, I'm not giving any word limit, right? You do your prose, and then you do not more than, right? Not more than 6 slides to guide your presentation. And let me get all this latest by Thursday, midday, right? Okay.
Sir.
Yeah.
So it's not going to be presentation.
It's going to be presentation, but I need to get it.
You want to get the slides?
Yes, ahead, and then you not only set the slide, you have prose as well. So you're supposed to do 2 things: your prose response, right? Your
okay.
It's assignment as well.
The written essay, yes, sir.
And then what do you use for your presentation?
Yes, sir.